so very happy to see so many familiar faces from all these years, spent in Bonn. And I'm very happy to be chairing this first, indeed, the first panel in this conference. And our first speaker in this panel will be Werner Gephart. We'll first hear and also see a presentation by Werner Gephart. And then we'll have a panel of 4 distinguished discussants who will give their comments to the presentation. So Werner Gephart, of course, needs absolutely no presentation in this collegial circle, but we should not really be, treating the rituals lightly, so to say. So I will, if you permit me, present our speaker. Werner Gephart is a legal scholar, a sociologist, and also an artist. And he is, as we all know, a founding director of the Käte Hamburger Center for Advanced Study in Humanities, Law as Culture. And he's been visiting professor all over the world. In 2019, he was appointed as president of the jury senior of the Institut Universitaire de France. And he's also the publisher of the series Law as Culture and co-editor of the volume Recht in the Max Weber Gesamtausgabe. His publications, as we all know again, center on the cultural analysis of law, sociology of religion and aesthetics. And he's also co-editor of the international journal Brill Research Perspectives in Art and Law. In 2014, Werner Gephart, along with German artist Anselm Kiefer, was awarded an honorary doctorate in philosophy by the University of Turin. And since 1988, he has held numerous exhibitions in Paris, Düsseldorf, Cologne, Bonn, St. Louis, Houston, Bloomington, Minneapolis, Tunis, New Delhi, and London. So again, all around the world, virtually. And among his many publications, let me just point out The Law and Economy According to the Studies of Culture of 2018, From Natural Law to Cultural Law, Cultural as a New Source of Normative Validity of 2015, and also a volume, an excellent volume, if I dare say so myself, co-edited with Jure Leko, on the Corona Normativities, the Permanence of Exceptions, just published this year. Werner, we are so looking forward to hearing your words on the law as culture paradigm. The floor is yours.
Thank you very much, Marta. I forgot to say that we met first during a conference about Max Weber, where you did a fascinating talk about Weber's view on the Polish question. And so this incited me to be more and more in touch and in communication with your work. And this was a great experience for me, if I may say this, and this is allowed to formulate it like this. So I'm a little bit embarrassed because I spoke before, and once again before, all those who have enough of Gephart may leave us now, and I will try to be rather short, and I'm much more interested in directions and erections and and reactions. Sorry, in order to see what I could learn from your perspectives. So I may start with the image. This is on the folder you have seen on the flyer, and it is Durkheim and Mauss under the tree of knowledge, and in an atmosphere of the wild thought, and especially they are vested in a way that they never have been and could be in this kind of landscape. So if you see also that Durkheim is situated in an armchair, you might understand how much this is a critical, ironical representation of armchair ethnology of the law. And so I would like to start with that, because we have to make a lot of reflections before starting to analyze a certain legal culture, because we start by projecting our concept of the law into that specific area, judicial scape, as I like to say. But we have to think before and reflect from which part and point of the world, we try to escape from our necessarily bounded Eurocentrism. That's the first epistemological point of what I would like to call the paradigm. So, and then I have tried to make yes, a follow-up of rules. And if it is formulated in French, don't feel afraid of that. You might remember that I was interested to decompose the concept of law into different dimensions, a symbolic, a normative, a ritual, and an organizational one. I think even this step is very fruitful in order to grasp more than just the pure content of normative expectations. It is gives a more vivid, a more lively image of the law. It comes closer to the idea of lebendiges Recht, but lebendiges Recht is a little bit too vague for me. So that's why I prefer this way. A second rule is to bring law in touch with religion. You see the image behind. Yes, of course. Impossible to do sociology otherwise than to do it as a legal sociology or a sociology of religion. You do both. But if you bring them together, it becomes even more interesting, and Judith Hahn might agree or not. We will see that later on. I go to the third one, of course, globalization. We know too well. I had, when we were in the third year, really the expectation that specialists of globalization theory, as Martin Albro, or internationalists in law, like Matthias Herdegen, could perhaps even more profit from one another by saying, yes, in international law, the globalization guys and girls might give a good lesson for us, and the other way around. But this did not happen until now, I would say. There is still a lack of bringing them closer together, and with all the ramifications and sophistications we had meanwhile in the globalization discourse. The fourth rule is, of course, the consequence of law and religion spreading over the world in a globalizing mode, bringing different legal cultures into contact and overlapping areas that might lead to conflict, as we know. And that is why this kind of a clash of legal cultures, without reminding us too much to somebody who thought it would be indispensable to go in this direction and to go into a catastrophe, social catastrophes. I think there might be and can be possibilities to rule and to handle this type of conflicts. It is a necessary step in analyzing a legal sphere, as I would like to name it. And as the fifth one, it had been to make a relationship with the artistic side, or with the art side, with the aesthetics of the law, as one could call it. But of course, one had to avoid to go into the direction of a, so to say, a kind of how do you say for this in political terms? Yes, a fascist way to make politics, or to make a glamour to politics, or to make a glamour to the law. This could also go into the other direction of becoming a kind of kitsch, of legal kitsch. And I think to work about legal kitsch would be interesting in this context. In the end, the question is what makes really the unity of such an orientation, where, as I said before, the question for culture as the main source of normativity becomes important and to be discussed, of course. I hope you understood the conclusion by the effet de manche, what is a corporal symbolical element, in a certain judicial space, one can say, in time and as a specific location, in robes that are similar to religious inscenations. And so I think one might resume it in this way. How to realize such a paradigm? I go back just to some elements of the center, without saying that law as culture could only be produced in the specific setting of our center, of course not, but cette tension entre liberté de la recherche et programmation de l'innovation, this was very fruitful, I would say. And one had to handle this tension, and I think it was very fruitful. Temporality and continuity, it is to identify a certain progress. Jacques et tous les autres qui se connaissent en matière d'organisation des sciences, c'est toujours le travail le plus difficile de se dire oui, j'ai fait un petit progrès et c'est exactement ceci ou cela. C'est pourquoi pendant les premières années de cet institut, j'ai demandé à la fin de l'année aux collaborateurs, est-ce que vous avez fait une nouvelle connaissance? C'est ridicule un peu de le dire de cette manière un peu pédagogique et aussi magistrale, mais c'est important. Et de le dire pour soi-même. Et pour pouvoir dire à la fin, on a fait des progrès ou non. Mais qu'est-ce qui est le progrès qu'on a fait? Je trouve ça très, très important. Et pour un certain moment, on a vraiment beaucoup travaillé avec cette idée-là. Coprésence et la constitution d'une communauté occasionnelle d'apprentissage. Bon, la logique prémoderne, nous allons encore en parler. Prémoderne, nous avons vu quand nous étions sur les écrans comme maintenant aussi, et combien nous avons souffert, nous souffrons toujours, et nous avons soif vraiment de l'autre, de la situation aussi corporelle, de s'embrasser et de tout cela. Et si nous ne voulons pas inventer des robotaires comme au Japon, pour nous livrer ce sentiment d'être des êtres humains à travers des êtres non humains, je suis assez content si en ce moment on peut un petit peu revenir au normal, bien que en même temps ça semble d'être assez dangereux. Je continue maintenant. Rencontres et conflits des cultures de savoir. Bon, seulement pour vous dire quelques disciplines que j'aimerais voir s'approcher ou collaborer avec cette perspective de law as culture. Alors, à travers le côté symbolique du concept de droit même, it is possible to include studies of literature, studies of art history, semiology, linguistics, etc. If you bring in this symbolic element into the law. The ritual dimension brings theater studies, theology, history into the discussion and into the discourse about the law. Once again, the departmentalization of the concept of law allows for new combinations with other disciplines. It invites to interdisciplinarity, even the concept of the law. That's what I will try to say. And I could continue. The law and the social sciences, for example, we have an example with Günther Jacobs, a dogmatic specialist in penal law, but who uses sociological categories to make a system of imputation, of penal imputation. It's a fascinating study. Or to bring philosophy once again into the debate about the law, and had never been lost. This has been a book by Rainer Saschik, meanwhile translated into Chinese, and etc. Or to take the study of law through the lenses of family law and to bring it in touch with cultural concepts of the family that are evolving, as we know, and to bring more adequacy into that relation between evolution of a legal institution and the evolution of a social institution is one of the main challenges that we have not nowadays. It is the main topic of any kind of sociological analysis of the law. And finally, some examples about des pratiques esthétiques et les sciences humaines. Some of you might remember Antje Krog. She made a conference here. And I have some difficulties to look at myself, but after her talk, a whole crowd of 30 people who do not live too close to this watershed of breaking out into tears were in tears. It was a collective emotion that spread around. It was incredible, and something happened with us. Or the wonderful movie by Samadhi Ahadi, who was so touching. And to bring in, it has to do with bringing in emotions, of course, into the concept of the law. Or, of course, we had the debate about refugees in Europe, and the Zaun by Benjamin Stöß got the Civis Prize in 2015. He was just a young collaborator of our center. Or we will talk about his work and with him tomorrow in the context of, do sculptures may have a normative power, and in which kind of sense? Le Rose Vallon Institute has been mentioned at several times, and it was very important, at least for my understanding of the problem, how an institution could become an artwork in itself, with all the question of boundaries, historical boundaries, what is still part of, for example, we had a great colloquium during the exhibition in Kassel, during the Documenta, and in the conception of Maria Eichhorn, I think, and also as I understand it, this conference has been part of the artwork. Finally, Droit et les Arts, we have done 2 books about that, Law and the Arts. I think a rather interesting one because it included not only law and literature, even I think no article about law and literature, but all the rest about law and architecture, law and music, law and sculpture, etc. A lot of things that had not been thought so much, at least, in before, and we think Juliko and me to have brought some kind of novelties into this debate. The same is true for narratives in the criminal process, a conference where Greta Olson also participated in Bergen in Norwegia. And I think it is an interesting one that you see here, the 2 Grimm brothers. You have understood and why I put them just into this context. There is no need for further explanation. Finally, some applications of the concept that I would like to show, and you know this premier exemple, une échelle glissante de validité, something I had worked out with together with Raja Sakrani. It is about making a difference, but also similarities between religion, law, morals, and fashion. Fashion, that what has been an absolutely legitimate topic at the end of the 19th century, and only now raises some kind of questions. I would have liked to make a conference about law and fashion and say, oh yes, really, you like fashion, we know, and this would, no, it is very fundamentally meant. There are periods where, let me say, human rights become part of a fashion movement. And so we have to react to this kind of interpretation and to see, is it fashionable, a certain way to think the law, and does it really discredit the way you do it or not? And the other way around, is there a way to think fashion without a normative framework? How to present and represent the body by way of a code vestimentaire? Of course not. There are a lot of, it's surrounded, the whole fashion field is surrounded by very strict normative rules that change over time, as we know, by coding the body, by coding the way we do fashion. And fashion, if it goes beyond just the code vestimentaire, it is even more important. And this can be analyzed in those categories of validity. The second example, culture de validité pandémique. All those who have participated in the first and the second volume will know that the belief in validity, the symbolic aspect, the normative, organizational, ritual dynamics do constitute a kind of ideal type of a pandemic validity culture that can be very well defined and, of course, is not to be found in reality, as no ideal type can be found in reality, but it can be compared to different modes of realities in plurality, and that means it might be fruitful. So, for example, when it was the question, your two books, is it really critical? Did you see the problems in all the rulings that we have? Safety first and security over the well-being of children and elder people. Can't you read suicide rates, etc.? Do you really think that obedience to the law is the remedy to this pandemic? I can only say even the concept of pandemic validity culture is a critical one. And this, of course, could open up a debate about the question in how far the law as culture paradigm has to be understood as a critical one, with a critical intention at least, or just, and sometimes I had the feeling that people would perceive it like doing a little bit more decoration to the law, and yes, sophistication, and if you have a background in literature and in art history, so you see even a little bit more. It is not about this, at least in my understanding of law as culture. Culture is a value-loaded concept and means also the avoidance of non-legal cultures or of legal non-cultures, of Unrechtskulturen, for example. So I would say this critical element is even embedded, implied in a concept of law as culture. So these are the two books that came out. Conclusion. Unfortunately, I think Peter Goodrich is not with us. It has been this image of David Paul Schreber, former Oberlandesgerichtspräsident in Germany at the end of the 19th century, who has been the object of analysis, psychoanalysis, by Sigmund Freud and by others who had a really very, very bad destiny. But he's an interesting case. This book came out. With this book, in this book, I tried to make a contribution by saying, this poor David Paul Schreber, who fled into psychotic imaginations and psychotic behavior, flew from something that was embedded in his professional life. And this, I would like to call it an over-rationalized structure or atmosphere, or yes, a life of the law at the end of the 19th century. So a lack of a lack of emotions in the concept, in conceiving, in understanding the law, and also in relating to it. How do we and why do we obey rules? That's an old philosophical question. But whether the acceptance of norms and rules is linked with an idea about the legitimacy, and it is value-loaded and also emotionally felt, might play a major role in the question whether a normative order as a legal order may be relevant for a certain community or not. So I think I came to the end of my presentation. It was half an hour, not more than I had promised. Thank you very much for your attention.
Thank you. Thank you very much, Werner. Thank you for this excellent presentation. And let me just tell you one thing. We are really fortunate to have the panel with us to help us get all we can out of this incredibly rich material. The first panelist is Judith Hahn. And Judith Hahn, who has also been presented to you before, but very briefly and not formally. So I will do it formally now. She is currently professor of canon law at the University of Bonn, and she studied Catholic theology and St. Georgen Graduate School of Philosophy and Theology in Frankfurt, Main. And she also studied at Suntrup College in London. Then she started her canon law studies at the Department of Roman Catholic Theology in Münster, and then there she received her doctorate degree in 2008. She worked for many years as professor of canon law in Bochum, and then as a department of theology and of the Catholic University of Eichstätt-Ingolstadt, and also at the University of Münster. She is also, and that's the most fascinating, for me at least, aspect of Judith's rich biography, she is a judge at the Ecclesiastical Labor Court. From October 2015 to March 2016, she was fellow at the Käte Hamburger Center for Advanced Studies, and she produced, both as a fellow, as we like to think, and otherwise probably, excellent books which include The Language of Canon Law, to be published soon in Oxford Studies in Language and Law series, and Church Law and Modernity, published 2019 with Cambridge Law and Christianity series. So Judith, it's great to have you with us. Our next speaker is Greta Olson, and she is a member of the Center's Scientific Advisory Board and also a professor of English and American Literary and Cultural Studies at the University of Gießen. Greta works in the areas of cultural and narrative approaches to law, critical American studies, media, and feminism and sexuality studies. And her recent publications include Beyond Gender, Features of Feminist and Sexuality Studies, How to Do Things with Narrative, Cognitive and Diachronic Perspectives, and The Politics of Form. The monograph that she began as a fellow at the Käte Hamburger Center, Law as Culture, the title of the monograph is From Law and Literature to Legality and Affect, will appear shortly. Greta, a very warm welcome to you. Where is Greta? Oh, there you are. Sorry, I was just trying to figure out where my panelists are sitting on my screen, which is not an easy thing. Our third panelist is Martin Ramstedt, and Professor Ramstedt is the director of the Oñati International Institute for the Sociology of Law, a very, very wonderful, lovely place, and we are so very envious, all of us, I'm sure. Where is Professor Ramstedt? There you are, Professor Ramstedt. Yes, now we'll see you. And Professor Ramstedt studied cultural anthropology, social psychology, European ethnology, and prehistory and Indian studies in Munich. He was also researcher at the Martens Institute, the Royal Netherlands Academy of Science in Amsterdam, has taught anthropology of law and anthropology of religion in the Netherlands, and at the International Institute for the Sociology of Law in Oñati, and also at the Oriental and African Studies School in London. Then from October 2006 until February 2012, he was senior researcher in the project group Legal Pluralism at the Max Planck Institute for Social Anthropology in Halle. And of course, he was also a fellow at the Käte Hamburger Center Law as Culture from March 2014 to February 2015. And let me just point out to you one publication of his that seems very relevant to the presentation that we've just heard, Religion in Disputes, Pervasiveness of Religious Normativity in Disputing Processes, published in New York in 2013. So Professor Ramstedt, happy to have you with us. And last but not least, our next speaker and a long-standing friend is Jan Christoph Suntrup, who is currently at the University of the Bundeswehr in Munich. He was a visiting fellow at the École de Droit de Sciences Po in Paris and also at the London School of Economics and Political Science. His doctorate degree, summa cum laude, comes from Ludwig Maximilian University in Munich. He was also a stipend scholar of the German Academic Scholarship Foundation and a lecturer at the Geschwister-Scholl Institute for Political Science in Munich. He worked as a researcher, research coordinator, and fellow at the Käte Hamburger Center for Advanced Studies, Law as Culture for 10 years, from 2010 to March 2020. And his two publications that are especially worthy of our consideration in the context of our presentation always would be Umkämpftes Recht zur mehrdimensionalen Analyse rechtskultureller Konflikte durch die politische Kulturforschung, published in the Bucholc series, and Formenwandel der französischen Intellektuellen, published 2010 in the series Gesellschaft und Kommunikation, edited by Werner Gephart and Daniel Witte. So, Jan, so very nice to see you. And thank you all for accepting our invitation to take part in this panel. And we are so very much looking forward to your reflections on Werner Gephart's presentation of Law and Culture Paradigm. And let us start with Judith Hahn. Judith, floor is yours.
Well, thank you very much for the friendly introduction. It's wonderful to see so many friendly and familiar faces. I'll try to give some couple of minutes, just a few notes on my view of law as religion, maybe. So thank you very much for the invitation to contribute some considerations from my perspective. I'm speaking as a theologian and as a canonist, thus as a scholar studying the law as culture paradigm, as I just indicated, in particular in a law as religion sense. I would like to mention but one example to show how the law as culture paradigm, as cultivated and lived here at the Käte Hamburger Center, has influenced my recent work. In studying the sacraments of the law and the law of the sacraments, I've endeavored to approach the symbolic, normative, ritual, and organizational dimension of laws which structure religious communities and determine religious action. I focus by way of example on the Catholic liturgies and worship. It is here where we can observe, as I want to suggest at least, in a nutshell, how strategies of ritualization set apart the sacred from the profane, and also the good from evil, pure from impure, right from wrong, to generate the sacred and to stimulate and reaffirm ritual action. Connected with these binarizations is their ordering function, as Catholic worship does not resolve the sacred and profane binarity, but arranges it in hierarchical schemes, thus placing the sacred over the profane, the good over the bad, the pure over the impure, and also the clergy over the laity, as you probably know. So in doing so, the Catholic liturgies not merely follow liturgical law and liturgical orders, but they also serve as producers and reproducers of law and order themselves, as they ritually perform a hierarchical order and thus symbolize the organizational functioning of the church in its hierarchical normative structuring. Werner mentioned, and I fully agree, that the law has a particular genetic and structural kinship with religion, and therefore requires an immanent attention based on the sacred and the profane. The Catholic sacraments, as I find, are perfect examples to show that intrinsic connection by presenting an intimate amalgamation of law and religion. According to Catholic doctrine, sacraments are evidently religious symbols. They are real symbols of grace, as they both signify and cause grace. Yet at the same time, they also serve as legal symbols, which signify and convey legal effects, insofar as they create membership, bestow church members with specific social and legal statuses in church, and endow them with competencies, authorizations, rights, and duties. Examples may help to see this. If you think of baptism, washes away the sin and marks the baptized individual with an indelible character as a child of God. Yet it also integrates baptized individuals into the church, endows them with legal personality under canon law, and bestows them with the rights and duties of the faithful. Marriage is another example, is a source of merit and grace for the spouses, However, their marriage contract is also a legal reality endowed with marital duties and rights, etc. One could name a couple of more examples. These examples show that sacramental effects as conveyed within the Catholic sacraments are not merely spiritual goods such as grace, but also legal goods. This concurrence of spiritual and legal effects is possible because the Church, what I want to argue is similar to all human communities, makes use of sacramental action to achieve changes in the status of its members. It uses declarative speech to bring about spiritual, social, and legal realities and to convey them to the Church members. One can draw the observations from this finding that political, legal, and social rituals, which change the reality of those involved and are studied as such by anthropology, ethnology, and cultural studies, also legal studies, share obvious characteristics with religious sacraments or religious rituals of what I would call a sacramental nature. I therefore argue that sacramentality is not an exclusively religious category, but that it may denote all symbolic action which signifies and causes what it signifies by using performative speech. In the aftermath of the Council of Trent, the sacraments came to be regarded mostly as a Catholic obsession. However, studying the findings which ritual theory, symbol theory, and speech act theory have made over the past century, we can discover that sacramentality is not specifically Catholic, maybe not even a specifically religious or necessarily religious phenomenon. Legal scholar Harold Berman noted with respect to the use of performative language in the law, and I quote, "We would compare such performative utterances in law with the sacraments of the Church, which are called effective symbols because they effectuate that which they symbolize," end of quote. This description is surprisingly close to the definition of the sacraments as given by the Council of Trent. With regard to the law and ritual debate tends to call the sacramental functioning of the law legal magic. Theologians tend to have rather negative view on practices which we commonly call magic, but closer study reveals that a non-pejorative understanding of the term is not too far off from those social practices which we call sacraments. Similar to sacramental action, legal magic makes use of declarative speech to create legal effects. It relies on symbols with the sacramental functioning to effectuate changes in legal status by creating legal persons or institutions, or by stripping persons of legal personality, by defining or redefining the status of persons or things, by changing the status of persons, for example, by endowing them with authorizations and powers, obligations, duties, and rights, or by taking these deontologies away. The law performs this magic, for instance, when it relies on the ritual of inauguration to promote someone from being a private individual to becoming a public official. With the help of a public official, the ritual of marriage transforms individuals into spouses. The judge who convicts defendants turns them into offenders in the eyes of the law, regardless of their personal guilt. The sacramental quality of penal adjudication is most obvious in the liturgy of adjudication, which celebrates this transformation. A court which declares missing persons dead renders these individuals dead in the eyes of the law, regardless of their true physical condition. These legal rituals, as I want to call them, the legal magic they perform, work in a similar fashion to religious sacraments, insofar as they declare and effectuate changes in legal status. This shows that the law has a sacramental functioning whenever it relies on declarative speech to change reality. It is this quality of the law to which I refer in my studies when speaking of the sacramentality of the law. However, studying these and other rituals shows that declarative speech requires the correct procedure to be effective. It requires authorized persons, certain performative actions, and particular circumstances to convey its effects. By uttering the right words, performing the correct gestures, religious, political, and legal agents achieve certain results which have a binding effect on the religious, political, and legal community. These conditions are conventionally established. They're established by laws, by social norms, by customs. It is this attribute of sacraments to depend on a normative foundation to which I refer in my study when speaking of the legality of the sacraments. As with all sacraments, the Catholic sacraments require conventional procedures to be effective. They require authorized persons, certain performative actions, such as the official formulas and correct gestures, and proper circumstances to bring about their effects. The liturgical norms, as found in the liturgical books and in sacramental laws, established these preconditions to ensure that the sacraments are celebrated validly. So the Catholic Church relies on the law to grant its members access to sacramental goods. It draws upon the law to generate spiritual goods, such as grace, but also legal effects, such as membership of the church, legal personality, authorizations, powers, rights, and duties. Due to these observations, one might call the Catholic sacraments sacro-legal symbols in a double sense. They're legally structured to grant their sacramental effectiveness. Their effectiveness, in any case, is manifold. They carry spiritual, legal, and also other social effects. Based on these findings, I studied the sacraments and their connection with the law from two perspectives. First, I studied the sacramentality of the law as the performative quality of the normative to change our reality by performative action. And second, I studied the legality of the sacraments as the legal structuring of real symbols, which induce their effectiveness. The results of my findings are hopefully published in book form soon. However, my work in this field, law as religion, would not have been possible without a profound formation according to the law as culture paradigm, for which my time at the Käte Hamburger Center laid a solid foundation. Thank you for this and also for your kind attention.
Thank you very much, Judith. And we move immediately, because we still want to have a while for the discussion afterwards, to our second speaker, and that is Greta Olson. Greta.
Thank you so much, Marta. It's lovely to see you again and to see many people who have, as I'll be talking about later, everyone on this panel actually was quite influential with what happened to my own work when I was at the Kolleg. So I'll be quoting you all in a little while. It is the nature of things. I don't want to just say what the Kolleg did and how amazing it was for my work. I'm going to say that. I also want to give it a little bit of pushback. I am so enthralled as someone who comes from a cultural studies paradigm and a material historical paradigm by the idea of 5 dimensions of law, a notion of being able to say with some certainty how law interacts with other forms of society, whether that's through systems theory, whether that's through actor network theory, whether it's through a Weberian or Durkheimian model of dimensions of law. I am on the one hand awed by that, if you will, totalitarian perspective. And on the other hand, I deeply believe in the partiality and incompleteness of our knowledge. And that's where I start from. And for me, and this is something that has evolved over time, I had difficulty with the Recht als Kultur, law as culture paradigm, because it suggests that there is one culture, simply in the terminology, and not an overlapping, contested heterogeneity of areas that are in complete contestation, or that cultures are any one thing at one time. Those are areas where I push back at this wonderful heterotopia of things that I learned at the center and that I continue to learn from. Living in a postmodern era, there are no grands récits, there are only petits récits. So to describe Recht als Kultur in a totality is to suggest a grand récit. I'm not sure we can do that, but I believe that every single person who had the great pleasure of learning at the Kolleg, like myself, was able to develop her or his own récit or effective resonance with which they, she, or he could add to a cornucopia of a very full horn of suggested measures. And to further to the conflicts, this resonates very deeply with me, because in all of the political work I do, taking a philological or cultural approach to things, I'm trying to do political work. And to see culture as inherently conflictual is something that I found in the center. And I found it both in the theoretical work of people like Werner, and also someone I learned so much from, Jan Suntrup, but I also found it in the pragmatic work of Nina Detlef, looking at adoption or notions of family across Europe, and how, for instance, German law is behind the ball in terms of queer families. And finally, what I'd like to say, and this is a piecemeal reaction of how much I learned, how much my notions of law and literature and law and culture expanded, things I'll be talking about a little bit more later. I want to talk about what Werner ended with in his presentation today, and also one of the last live events that I had the pleasure of joining in Gießen. Martin and others of you were also there. That was Law as Emotion, which Raja, amongst others, celebrated. And you ended with Schreber, Daniel Schreber, Werner. And I think in work that I've been doing with Laura Borchert on transing law and developing a notion of sexual legal personhood in a volume that's just appeared edited by Daniela Grandhofer, Cecilia Gebroyers, and Peter Goodrich, already mentioned today, is a notion of pushing back against a paternalistic version of law that imposes a steady sexual identity upon people, and says, for instance, whether this is in the German or the American case, you are too young or immature in order to be able to determine your gendered identity as non-binary or as trans, or one that threatens with an image of an imperiled woman those who are trans from expressing their identities. And I think the notion that you are getting at, it's also a conflict, it's also huge in the United States right now, with a swath of anti-LGBTQ and anti-feminist legislature. Roe versus Wade is being pushed over as we speak, is to say the future for law, for me, is a transing law, allowing people, and this goes beyond sexuality or gender, but allowing people to have the freedom to have non-permanently determinate gendered identities. And I see this in Daniela Schreber. Thank you.
Thank you very much, Greta, for these great remarks, which also resonate with my own work, but maybe I will get to speak about it yet. But now we continue with our panel, and the next speaker is Martin Ramstedt. Professor Ramstedt, please.
Thank you very much, Marta. Thank you very much, Werner Gephart and Greta. I'm really happy to be here today. What I really appreciated and enjoyed during my time in Bonn was really the liberty, the Freiraum, it was said, to think not necessarily coherently, but letting oneself be inspired and express thoughts that might lead eventually somewhere, but not necessarily immediately. And in this spirit, I want to give some comments, particularly on Werner Gephart's 5 to 6 rules, and not necessarily in a coherent way, but maybe in the end there might be something of value resulting from it. As to the first rule, which basically says that the analysis of law as culture addresses the symbolical, normative, ritual, organizational dimension of law. Yes, from an anthropological theorizing, I can agree with that. But what kind of research questions can this distinction inspire? Which is, as a researcher, is very important to me. It is important, I find, for me to ask, for instance, what meaning and or function do members of a certain society ascribe to law? And what do their answers say about themselves and their society? It's a difference when they might possibly answer that through law, order and peace is attained and maintained, or through law we claim, defend social justice, or that law is the foundation of democratic decision-making. All these answers tell us different things. We, of course, need to methodologically reflect on how we can interpret these answers, which actually necessitates to think more deeply about how we can combine different methodologies from the social sciences and the humanities. Maybe this is an encouragement to do this more. Another important question for me is, what symbolical status do members of a certain society accord law? And what does that say about themselves and their society? Like, our law is divine law, or law is merely a mechanism to ensure reliable trade relations, which was an answer people were giving to me in Indonesia. Another important question to me is, do people see justice as a property of law, or even as a necessary property of law? With regard to Werner Gephart's second rule, that the genealogical and structural relationship between religion and law necessitates that they are analytically treated neither as separate fields nor as separate systems. I think that the concepts of religion and law, which you introduced, Werner Gephart, are clearly embedded in the culture of Western liberal modernity on one hand, and Abrahamic religious cultures on the other. In non-Western modernities, in any case, and that applies to both Islamic and maybe Hindu or indigenous modernities, law might be identified with the foreign and religion with the self. Law and religion might therefore be seen as completely different, perhaps even irreconcilable spheres. Whereas in indigenous societies, indigenous or customary law might be seen as an aspect of the indigenous cosmology, that is to say, as part of the same sphere. Law and religion might genealogically not at all be related, or they might hardly be distinguishable or distinguished, depending on the society in question. And we need to bear this in mind, the variations along a continuum. In Western liberal democracies, religion is circumscribed by secular state law. In some countries of the global south, such as Indonesia under Suharto, for instance, corrupt jurists and the fact that secular state law primarily benefited only certain elites and or foreign investors and international trade relations led people to dissociate justice from secular state law. Religious promises and concepts like divine justice, karma, etc., took the symbolical space of justice. A significant number of people started to associate justice only with religious law. In the case of Indonesia, mostly Islamic law, maybe Hindu customary law. In India, maybe Hindu caste laws or Christian canon law in the south. Since the collapse of the Suharto regime in the wake of the 1997 Asia crisis, this has led a large segment of the Indonesian population to believe that religious law should supersede secular law, at least in certain areas of life. I agree that with Werner Gephart that in order to understand normativity, one needs to study both law and religion in their various historical and sociocultural variations. As to the rule number 3, only if law is dissociated from particular and local validity relationships, we can speak of global law. Yes, if global is not equated with universal, I think there is a distinction here, and there should be a distinction here. And but just with the dissemination of legal norms across the globe, should globalization be associated, not with universal validity. Inspired by Karl Polanyi's analysis of Europe's great transformation, I see the disembedding of justice from local tradition, that is, traditional meaning-making and validity construction, as an effect of globalizing or traveling law and the resultant legal pluralism. This dynamic has prompted reactionary efforts of re-embedding justice into local culture, which we usually investigate under headings of populism, Islamism, Hindu nationalism, indigenism, and so forth. Sociocultural change can lead to the disembedding of justice from local law, which may stimulate calls for law reform by different social movements, like civil rights movements. I think that's another aspect of the double movement, as Polanyi said, of disembedding and re-embedding. Now, as to the 4th rule, overlap, interferences, clashes, and collisions of normative orders, I distinguish between normative pluralism and legal pluralism, and both are very much ubiquitous in our contemporary world. I define normative pluralism as the multifaceted entanglement of different state-recognized and non-state normativities. Legal pluralism, on the other hand, is the complex and multifaceted accommodation of different state-recognized legal orders in a common legal frame. This has implications for analysis. I don't have the space here to go into that. From the reality of normative and legal pluralism follows that justice cannot be posited as an absolute category. With Reza Banakar, the late Reza Banakar from Lund, I see it as an actor-oriented concept that can only refer to a quality of experience people make in concrete social relations, which themselves are always configured by multiple normative orders and power relations, of course. With regard to law and aesthetics being separate fields or systems, I see both normativity and aesthetics as transversal categories of analysis. They apply to all fields of social action. I just want to refer here with regard to normativity to Sally Falkmore's well-known concept of the semi-autonomous social field. Following German sociologist and philosopher Wolfgang Welsch in his observation that every aesthetic order anesthetizes certain aspects of social reality or social possibility, I find it useful to inquire what a certain aesthetic dimension of law obscures and how different aesthetic registers like narrativity, architectural design of legal institutions, clothing style of legal professions, rhetorical performativity, embodiment, etc., achieve the obscuration or obliteration of certain aspects of social reality or prevent certain possibilities from happening. With regard to the relationship between law and politics, I think that the increasing juridification of politics has indeed led to an enhanced lawfare. Now, this is a term coined by South African legal anthropologists John L. Komarov, meaning that lawfare means that one resorts to legal instruments to the violence inherent in the law for political ends. I think that's a valid, an interesting field of analysis. Another interesting field is the politics of the cultural translation of traveling law. An analysis of the politics of the cultural translation of traveling law requires attention to the socio-political events prompting the transposition of legal rules, institutions, and procedures from one normative order to another, attention to the history and connotations of the terms, institutions and practices to which the traveling legal norms, institutions and procedures are transposed, attention to the question of who authors and controls the translation of traveling law into the target languages and the respective normative frameworks, attention to what kind of socio-political interests are involved in the translation, and are there parallel and possibly competing translations or translation change? Do they interact, and if so, how? Ultimately, what is lost and what is gained in the translations? So cultural translations, attention to cultural translation of traveling law, in other words, motivates us to understand law as an integral part of culture and as an important lens to analyze cultural dynamics. Some final considerations. Legal consciousness of people might extend to non-state normative orders and therefore not be visible to legal scholars or sociologists of law conventionally investigating legal consciousness. The question then arises, on what grounds do people choose a certain normative frame to solve a particular conflict? How are aesthetic considerations implicated in their decision? Following Alexander Gottlieb Baumgarten's mid-18th century notion of aesthetics as sensual cognition, I argue that it is perhaps not only access to a congenial form of justice what people seek or wish for, but also access to a particular aesthetics of conflict solving, which might invite us to think more closely on culturally embedded expectations of effective reactions and interactions around law, in court, in legal procedures. Thank you very much.
Thank you very much, Martin. And now to our final speaker, Jan Christoph Suntrup. Jan, the floor is yours.
It's good to see you, some of you, after a long time, and it's a shame that we cannot meet in person today. It's hard for me after many happy years of working at the center to comment on the law's culture paradigm, which is well known in that circle, in 5 or 10 minutes. When I began here as a researcher in 2010, Werner Gephart didn't have to convince me of looking at law and the social world as culture. As I was being disciplined as a political scientist, I'm certain that we should do this with politics as well. And this is what I tried to convince my colleagues from political science of to this day, although many of them remain resistant to such a paradigm shift. Apart from that, I think I learned a lot about law as culture in those years, and also about law as law, by the way. And even on occasions I failed to learn anything at all. I was often a productive misunderstanding. At least it turned out such like this later. And this is what the paradigm is for me in the first instance, productive and inspiring. It made me realize how manifold the legal world is, how whole cultural worldviews become manifest in legal practices and images, and how complex conflicts of and around the law, way beyond specific norms and questions of authority, really are. For legal orders differ in their symbolic projections, in their narrative foundations, in their truth claims as well, and to become aware of those layers and dimensions demands an analytical perspective, which the law as culture perspective provides. Speaking as a political scientist, this perspective is, to my mind, very revealing and even necessary with regard to all kinds of constitutional questions. This is rather obvious, as constitutions are meant to be the foundations of political order. The sad case of Afghanistan, which I've worked about a bit, has shown that those foundations cannot be transplanted at will. But there are other cultural specifics below the constitutional level that are probably less obvious of political importance, but no less relevant on closer inspection, such as competing models of procedural culture in war crime tribunals, different visions of fairness, of testimony, of truth production, which have effects on the role of witnesses and the politics of memory. My present work is focused on the state of exception and emergency politics, and here again I am convinced that we cannot fully understand how politics and law are transformed in times of multiple real or projected emergencies without a cultural perspective. States of emergency always reveal a lot about a society's constitution in a larger sense, about a political form that is a product, in Claude Lefort's words, of mise-en-sens and mise-en-scène, production of meaning and symbolic staging. For example, when authority claims are embodied, security and sovereignty phantasmas are materialized in walls and fences, iconic and historical analogies are established, for example, between 9/11 and Pearl Harbor. Savior claims are staged, human beings are symbolically degraded to unpersons or even animals, or acts of resistance are performed, sometimes even in the form of law, in the case of the notorious Querdenker in Germany, who once proclaimed a constitutional assembly to save, that was at least the official justification, the true spirit of the German basic law. In all these respects, the law's culture paradigm may be highly useful for political scientists and others. I would like to conclude with a short reflection on the concept of paradigm. And I don't want to bore you with the historical development of this concept, but just recall how Thomas S. Kuhn tried to clarify this concept after considerable confusion in the structure of scientific revolutions. In a larger sense, a paradigm is a theoretical, methodological, and evaluative framework within which scientists conduct their research. Kuhn later innocently called this disciplinary matrix. However, this term must be compelling for anyone acquainted with the work and concepts of Michel Foucault. And even though Werner Gephart introduced the law as cultural paradigm today by establishing a lot of rules, important rules and ideas, I'm very thankful for the fact that at least my experiences here at the center were not impressed by scientific rule fetishism and disciplinary subjection. And in this regard, the work at the center is paradigmatic in a narrower sense, serving as an exemplary model for future research. Thank you.
Thank you. Thank you, everyone, for these great contributions in which the testimony of your time at the center was intertwined with the reflection on your scientific work. It's a wonderful evidence also to the importance of the personal in the intellectual, if I may put it that way. And now we still, I'm very happy to announce, have almost 20 minutes for the discussion. This is unprecedented, and I'm overjoyed to open the floor to everyone, including our presenter, who I am sure will be willing to react to much of what has been said. Yes, Judith, please.
Thank you very much. As always, one learns the most when listening to others and not when speaking. I would like to maybe take up one thought which you raised, Martin, Ramstedt, whereas I was nodding at first, thinking, yeah, I think you're perfectly right in saying this connection between law and religion is a very Western thing, or something that's connected with Abrahamic religions and our understanding of, law as religion as law, if one wants to put it that, with regard to, I think, Jewish law and Islamic law, we could validly say that, and also for a tradition of canon law, where I come from. I was wondering, though, if that's a necessary incompatibility with what Werner said, because the connection which I also made between law and religion, for me, is more one of a foundational level. I fully agree. I mean, in canon law, we have the experience. If you come to Asian countries with our wonderful global canon law, and they say, okay, what should we do with this kind of weird normative idea, which is very Western and is imposed on other cultures. So this problem, which you also raised with global law and universal law, is something that very much relates to what I'm studying. But I was wondering if we understand not the concrete religious systems and legal systems which clash really in many cultures, but what I tried to discuss, something which we could call religion in the sense of processes of distinction between the sacred and the profane, processes, ritualistic processes using performative speech to achieve something, to bring about something magically, if you want. If then this, I'm just asking, if then this is something which might not be at the root of phenomena we call law, it's maybe bold to say transculturally. I'm just wondering if there's something in this distinction, which I would call religion, not a concrete religious system, but this process of differentiation, which might be something which unites law, but maybe I'm fully somewhere else. I'm just wondering if maybe this might be an idea to kind of reconnect law and religion, also, though I agree, not concrete religious systems and legal systems.
Yes, Martin, if you'd like to respond directly.
Thank you very much, Marta, and thank you, Judith. Yes, it's important to reflect about this. I think one needs to distinguish, or what I would like to distinguish between foreign law and one's own law, what let's say law that or normativity that grows out of a certain society, in contradistinction to let's say law export, the law that is in, like traveling constitutions or something made in Germany, in Freiburg, ending up in Sudan, being adopted and never followed, things like that. Maybe that's what I wanted to emphasize. Of course, I think then there are all kinds of processes of cultural translation and accommodation, and I think that I have tried to show this in two publications on colonial Indonesia and colonial Java and colonial India, that even those who who are usually known or portrayed as recipients of law or normativity or religious norms or religious ideas, let's say recipients of traveling models in the translation process, which you need in order to make it valid on the ground, whatever is translated. You have co-authorship of members of local societies. Yes, in that sense, there's always co-creation and therefore ownership involved to a certain extent, I think. But I think we should really try to describe this. We need to nuance that in our approach. It is interesting. I mean, for me, it's fascinating to compare how canon law is translated to let's say the Philippines or to Catholic regions, Adivasi regions, or Kerala in India, for instance, and how this translation reflects back on developments in Western societies or in Latin American societies. I think that was shown by recent studies of Islam that I forgot the name, Tachman or something, a colleague from Berlin, whose name I forgot, who proved that societies conventionally thought of as marginal in the development of Islamic cultures or Islamic debates, Islamic theological positions were often rather central because they were just being present in Mecca, or because the route the ideas traveled were not just from west to east, but were circular or in any case more complex than one has thought. Maybe that's a good reply. Thank you very much for this stimulative question.
Thank you. And now we have Greta.
Thanks so much. It's wonderful to hear you all. I'm deeply in accord with Judith. One learns more by listening. 2 points that resonated with me in what Jan and Martin said was the conflictual quality. Maybe it should be law as conflict. And Martin's lawfare. What used to be described as my own culture of origin, US American adversarial legalism, seems to be a phenomena that is spreading. And appropriately, Jan called his big book Kampf des Recht, Battled for Law, channeling Gießen. And I'm wondering if and as I look at Gießen as kind of a political philosophy and things that I'm doing now, and I'm trying to really open up the discussion, it's people go to law, whatever they want to call law, as a form of validity or legitimation when they are desperately unhappy with the political system. And whether those are Corona Maßnahmegegner or those who are in front of the Supreme Court right now because Roe versus Wade is about to be thrown over. I wonder if we could comment on that. Maybe another dimension of law would be law as conflict. And Werner, of course, you too.
Does anyone volunteer to react to Greta's suggestion? Well, because if nobody would, then I will very happily take the word for a while. Regarding the conflictual dimension of law, and also what you said, Greta, earlier about the direction in which law would be moving, the direction of the legal development. I was wondering, because, well, what you said was, if I take it correctly, that law would go in the direction of being more trans in terms of providing more opportunities for people to be who they are, essentially. So that the basic idea of law making a space for people in which to realize their, so to say, nature as social beings, this space would become bigger and bigger. This space would expand in the course of time. And I think it's a very optimistic view of whatever is happening. And in my own work, and of course I should say it because it also goes to the center's credit, I will in October I will start an ERC consolidator project in Warsaw on abortion and human rights. And I've been looking into these developments a lot recently. And what I see is the divergence between this anticipated, philosophically anticipated direction of legal development and the empirical direction. And the empirical one does not go in the direction of expanding freedoms. It goes in the direction of exactly resolving conflict, but cultural conflict, what we call cultural war, but by narrowing down these spaces in which humans can be who they are. So my reaction to what you are saying is, yes, law is conflict, but law is conflict whose resolution can go either way, so to say. The resolution is underdetermined, so to say. And we have Jan Suntrup immediately on that, and then Martin.
Reacting to Greta, I also think that law is naturally conflictual, but I don't think that we should add a dimension of conflict on the same level as in the analytical dimension of the laws culture paradigm. However, you try to model this dimension, because I think it's more worthwhile to think about conflicts about law, with the law, against the law in different dimensions. So how different conceptions of justice clash in a court of law, or in protest movements or whatever, or narratives of law and clash. And I think by using these dimensions, you can describe how conflictual legal views are, and you can also show, or you can get away from homogeneous concept of cultures. So you can describe the symbolic or narrative or whatever organizational conflicts within illegal culture and cultural modes of appropriation or authority claims to speak in the name of culture or whatever. So I think it's very useful and possible within the law culture paradigm to look at all those conflicts and not add another specific layer of law as conflict.
Thank you, Jan. And now we have Martin, then Nina Detloff, then Greta again, and then Werner Gephart. And if nobody else wishes to speak now, I think this will also be the closing remark by Werner, and then we'll move towards the break. Okay, so now we have Martin.
Thank you very much. I was thinking about Greta's law as conflict suggestion, and I want to rephrase it a little bit in the context of my recent work on restorative justice in the Basque Country, in the context of the aftermath of the Basque conflict and the ETA prisoners transfer from Andalusia to the Basque Country, to prisons in the Basque Country. I think we should ask ourselves what kinds of conflicts can a certain local law solve to the satisfaction of the society involved, so that peace, social peace is ensuing. And it's very obvious, for instance, that in Spain the peace process has not really been successful. Transitional justice has not taken place, and that's why the Basque government, with whom I co-organized one national conference on restorative justice involving dialogue circles, also with prisoners and victims associations, and also an international workshop just a week ago. It became clear that in the experience with directors of penitentiary centers, with ministers of justice, directors of justice present, directors of prisons and so forth present, that the Basque government really wants to implement restorative justice because as an integral part of their penitentiary model, because they have become convinced, and they have publicly stated so in a press conference at our conference, that restorative justice might be a way to complement existing justice to achieve more peace in the sense that victims are really heard, that the community is really has a voice and so forth. So I think, yes, it again forces us to concretely look at what is actually happening on the ground, and whether law creates more conflict or is really able to solve conflict, and if yes, to what an extent. In Indonesia, for instance, in Bali, judicial sentences are not enough. Every crime or every offense always also requires a ritual, a religious ritual, in order to really appease everything. Thank you.
Thank you, Martin. And now we have Nina Detloff.
Yes, thank you very much. I also wanted to comment on this very important aspect, Greta, the conflictual dimension that you mentioned. And I certainly see, especially with the view of the adversary system in the United States, which has been exported throughout the process of globalization to other countries as well. I see that point, and I see it in many areas of the law, also in the area of course, of family law, where dramatic battles are fought. But in that area, but also in other fields of the law, I also detect a different dimension, I would say, and that is the more collaborative aspect, and the aspect of putting negotiations and reaching peaceful agreements, mediation, and not only family conflicts, but also in many other conflicts, transnational conflicts included, to put that aspect more on the front line, so to say, and using the law more on in a way that is like the bargaining in the shadow of the law, and as has been said. And I wanted to draw your attention to this certainly also, I think, very important aspect of the collaborative or mediative law, so to say. Thanks.
Thank you, Nina, for this very important remark. And now, Greta.
I believe Werner was first, but it is appropriate that Werner should have the last word. So, just to come back to what you said, Marta, I see in the adversarial conditions in Poland and the USA this huge, where does a normatively authoritative law take the right to have control of people's bodies? And those are trans and non-binary people, and they're women, cis women, and or women, those who can become pregnant and do not have the right to control their bodies right now. And I'm deeply with you that this is, on the one hand, we have movements, we have efforts to reform trans laws in Germany. Argentina and other countries are really opening up to forms of self-determination. Britain is not. Germany is in stasis, and we see a country like the United States going backwards on this. And just to say, and thank you, Nina, for bringing up the mediatory and the mediation, but I see in my own country of origin how law is increasingly, since my childhood, become an area for cultural, political, and legal conflict.
Thank you, Greta. And now, Werner, we rely on you to just pack it up together as only you can.
I would like, so first of all, I'm very much impressed by this discussion. I have learned so much, and I'm very grateful to all of you. for having taken this kind of projection or proposition for this debate as seriously as you did. On the one hand, so I see that one can make it more precise and or more open, one can change, add a seventh rule, for example, and Jan Suntrup argued against it. And I would do it also because I, in my proper understanding, made no comment at all about the question whether law has something to do with integration, conflict resolution, with identity questions or whatever. I didn't talk in these rules about functions of the law. So then the question, the more general question would be for me, whether it's necessary to include this debate into the designing of a kind of paradigm. And I did not want to do more than this, where culture and cultural aspects as cultural embeddedness of the law and culture as a value-loaded concept of conceiving and understanding the law would be included. I didn't want to make anything more. So with questions to identity, queer identities, etc. Do you remember, dear Greta, that you translated some 20 years ago an article that I'd written about Marilyn Monroe, and it was about the body. And the question of how many bodies do we have? It's not only two, we have a normative body, we have a symbolic body, we have a real corporal, physical, and we have a social and a cultural body. We have 5, 6, even more bodies. All these bodies are embodied in our life, in our existence. And so how do they relate one to the other? Is the coding of a certain type of figure the main line that has to be pursued in Germany's next top model search for, or not? And what does it mean? So this can be analyzed in different contexts. And my aim in formulating this kind and developing this kind of paradigm has been intended, and this I say to Martin Ramstedt, really to be not universal as such, because it has no content. It is a perspective under which to look at the law. One perspective would be to see, on the one hand, the sacredness of certain normative expectations, and on the other hand, the purely, let me say, ordering factual effects of normative expectations. Perhaps one is closer to the law, legal sphere, another one closer to the religious sphere, when there is also meaning put and giving a certain meaning to the world, etc., is put into the understanding of those spheres. And so this was the intention. I'm not defending myself, you understand? I just want to explain and to give an explication for what I try to do. And I find it particularly for my proper work, I have found that I can work with it. Let me take the question of queer and other identities. So when you start to look at the symbolic level, for example, you look at the normativities behind, you look at how it is organized by the way of your passports, etc., and how it is ritualized to become a member of this community effect. So I see that invites you to ask certain questions. I do not want to say anything more than that this might be fruitful for getting a complex understanding for the normative complex, I would say, in the most general way, not to say normative order, or not to say just expectations, or not to say normativities. So this is my intention, and for my proper work, it has worked rather well, I would say. Whether this is true for others also, for example, you know, Rezeption und Rechtskulturwandel, europäische Rechtstradition in Ostasien und Russland. This is exactly an example of traveling concepts, and I try to analyze or to apply those rules to the aspect of traveling concepts and reception processes. So, and it works. And it's interesting, you come to certain results. Of course, one must know whether with other paradigms that are not excluded, a paradigm, even in the Kuhn sense, does not have any claim for unique validity at all. It is an instrument. It is an instrument, a tool, just to work with different realities. And in this sense, one really could think about the problem or the question how to introduce conflict. So in the last Simmel Handbuch that came out in 2020, I think I was endowed with the question to write about Georg Simmel's understanding of the law, what is not very well known in the world. Of course, by way of Louis A. Koser and his book about the functions of social conflict, we know that he relied completely on Georg Simmel in order to make a stronger view on the importance of conflict in social life. And this he put against the Parsons dominance, Torquay Parsons dominance of his and in his time. So this is very understandable. But when you look into Simmel's analysis of the law, then the third party comes in and other elements that have to do with figurations, with the fact of formal relations, the formality of those relationships, etc. So this is very interesting, but it is another access to the role and the importance of conflict in society. Of course, I do completely agree that this is a crucial aspect of understanding social life. Deswegen heißt auch das Buch von Jan Suntrup Umkämpftes Recht. Nicht nur, weil der Jähring dahinter steht, sondern weil das genau das umschreibt, was er in dem Buch auch macht, nämlich an der Reihe, am Beispiel vieler empirischer Beispiele zu zeigen, wie man das dort tatsächlich auch anwenden kann. Für mich, for me, a question remains is whether it makes sense to add, for my personal interest, I say, other dimension as the narrative dimension. This was the proposal of Jan Suntrup in his really great book, that Great Habilitation. The narrative dimension as having a proper logic in itself and being relevant for understanding the law, whether you are closer or more far away of a narrative paradigm. I would agree, this is very relevant for understanding different types of legal orders, legal cultures, etc. I think it is very important, but where you put it, you introduce it into the symbolic dimension of the conception of the law, or you make a new rule, an additional rule. I think that's a question of pragmatics, but I would always agree to take into account the importance of conflicts in analyzing the law. It is impossible to do it without that perspective. Or the same is true for narratives. So it should be understood at least as something that is an open and not a closed shop of how to do legal analysis as Kulturforschung. You understand? So that is my proper understanding. But the step to bring it into this kind of condensed form has been an advancement in my proper understanding how to do this kind of research. It can be more perfect, no objection at all. It can be, it might underline other aspects and departing of your theoretical perspectives. And you know that there is a lot of theorizing behind. It is really a very, so to say, reduced form of theory that stands behind. But if you want to apply it and to transmit it, for example, 3 weeks ago, I had with Diana Vilgas and Pierre Brunet and others talks and conferences in Paris, and I could see that it was able to apply to all kinds of different situations and also legal cultures behind in at least to me, a seemingly fruitful way. I don't want to make a defense talk. I hope it is clear, but just to make understandable why it is interesting for my own work.